This is Jonathan Yates with HBCU Game Day Network. I'm with Mike Phillips, an employment law partner with the law firm of McGuireWoods. Mr. Phillips, thank you for taking the time to be with us today.
Thank you for inviting me.
Mr. Phillips, in a previous interview, you said that the compensation issue was a major one facing college sports. Do you still feel that way?
Yeah, I think that compensation is still a big issue, although there's been some recent court rulings that have actually been favorable for the NCAA on the issue of paying players, but the sponsorship issue is obviously front and center right now.
So what have been the court rulings that have been favorable for the NCAA in terms of paying the student athletes?
Well, there were a series of cases that tried to advance a theory that student athletes were employees and were entitled to be paid like employees. There was a case in California that probably posed the biggest threat to the NCAA called Dawson. And in August, the Court of Appeals for the Ninth Circuit affirmed the dismissal of that case, basically threw it out and said that as a matter of law, student athletes do not work for either the NCAA or the Pac-12.
And so how would that have its ruling on the former football player for Villanova who's suing for minimum wage violations?
Sure. So, I mean, those cases, in my opinion, are pretty much dead for the foreseeable future. You've now got two circuit courts of appeal, both the Ninth Circuit, which sits in San Francisco, and the Seventh Circuit, which sits in Chicago. And they've both come out the same way. They've both said that as a matter of law, student athletes are not employees. They don't meet the test for employment under federal law. And I think those two cases are going to pretty much put a chill on any kind of athlete as employee theory for quite some time.
And it had pretty much been established that the Ninth Circuit was the highway to go to for these type cases, hadn't it?
Well, absolutely. And not only because the Ninth Circuit is generally regarded as the most pro-employee court of appeal in the country, but because the Ninth Circuit in this case had the opportunity to either find an employment relationship under federal law or under state law or under California law, which, as you may know, is often different from federal law and usually more favorable to the employee. But the Ninth Circuit rejected both federal and state.
That's very interesting in regards to the California legislature recently moving to allow for student athletes to be able to get paid for their image and to accept sponsorship dollars. So what did you think of that ruling?
Well, yeah, the legislation from the California legislature has probably been a while coming. It's not really based so much on the Dawson case, on the athlete as employee type of theory, but on a case called O'Bannon, which was an antitrust case that was decided by the Ninth Circuit in 2016.
And so the California legislation was following the federal legislation that was filed by Congressman Mark Walker and Congressman Cedric Richmond. They were previously on our show, and they're now working with senators to take it over to the House side and the Senate side. What do you think will happen up there at the federal level?
Well, I think that's interesting. I mean, you've certainly seen some opinions from members of the Senate, Senator Burr in particular, who we may talk about, seeming to be very hostile to this concept. But what's interesting, I think, about what you mentioned is that this is a bipartisan issue, that you have people on quite opposite sides of the spectrum who feel the same way, which is that athletes should be able to be compensated for sponsorships and endorsements and use of their name and likeness.
Now, in regards to the Dawson case, could you perceive where these state legislatures will start changing their laws so they could have another go at it again following the California legislation with the sponsorship issue?
Well, you know, what's been interesting, so what's really restrained the state legislatures is that no state legislature wants to do something that's going to hurt their in-state teams. In other words, if you're in the Alabama legislature, the last thing you want to do is have a bunch of angry Crimson Tide fans, right? So, you know,
particularly after the LSU game last week.
Exactly. So the paying of players directly from the university would be perceived, I think, by the member schools as a negative, as a drain on the budget and on the program, whereas the sponsorship issue is money coming from outside the program and doesn't put the local school at a disadvantage. In fact, it puts the local school potentially at a recruiting advantage.
So were you surprised to see Memphis State file a lawsuit for Wiseman and prevail, and to see Ohio State recently file a lawsuit so that its football player can play this week?
Right, and those are two different questions. Was I surprised to see the lawsuit? Yes. I mean, we've seen this tactic from time to time in professional sports, going to a local court and trying to get an injunction to allow a player to play. We haven't seen it much, if at all, at the college level, and it's an interesting strategy. It's a risky strategy, but I also think that the phenomenon of the one and done player at the college basketball level is part of the motivation for it.
Now, why do you think it's a risky strategy?
Well, it's risky because, as you know, the general penalty for using ineligible players has been forfeiture. And so if you're the University of Memphis and you've filed a lawsuit and you play the player, even under an injunction doesn't mean you're going to win the case. If you lose the case at the end of the day, I think the NCAA has every right to impose penalties, including forfeiture of any wins in which that player played.
Now, I've been following college sports for a long time. I don't think I've ever seen a tougher month for the NCAA in my life. They got rolled by the California legislature. They lost regarding the Memphis State player. Who knows what's going to happen with the Ohio State player, the Villanova football player. Just fine. What legal advice would you give the NCAA, or just looking at it from where you sit?
Well, I think the NCAA is taking a step in the right direction in terms of their ultimate reaction to the sponsorship bill. In other words, trying to create their own legal framework to try to regulate this instead of leaving it to the state legislatures or the Congress to impose regulations on them. I think that you're always better off making up your own rules rather than letting someone else make the rules for you. So I think that was a step in the right direction, but they've been very slow to recognize the fact that amateurism in the way they conceive it is slowly eroding, and they've been fighting a rearguard action, I think, against that, and as you can see, they're starting to lose that battle.
Now, previously you had mentioned Senator Richard Burr. After the sponsorship ruling came out and the NCAA decided to allow the players to collect, Senator Burr of North Carolina basically said, if you're going to collect based on the value of your scholarship that you're receiving playing for a school, you're going to start paying taxes on that. I know you're not a tax lawyer, but what are your thoughts about that?
Yeah, I'm not a tax lawyer. I can't speak to that aspect of it, but it does intuitively make a certain amount of sense. In other words, if you're going to be making money off of playing sports, then isn't it your job? And if it's your job, how do you say to the IRS, well, this part of the compensation I receive for my job is taxable income, but this other compensation that I receive for doing the exact same work is not. In other words, if the sponsorship income is taxable, what would be the argument against the scholarship money being taxable? And I think even in the absence of legislation, there's an argument that could be made by the IRS or other taxing authorities that scholarship money is taxable income if an athlete is accepting and reporting other types of taxable income.
Do you think that college student athletes realize how good they have it now and that they might be going into an area they don't want to when you talk about the sponsorship dollars and the taxation issue?
Well, thanks for the compliment. But I'm not sure they realize that. And I'm also not sure, from what I've seen and heard from college athletes, that it's really the athletes that are driving this, or certainly some of them are. But I'm not sure the majority of college athletes are really adamant about being compensated for their work, and I think, as you implied, it may create more problems than it solves.
I recently read an article in The Economist about ExxonMobil after the Valdez incident when their tanker went ashore in Alaska and spilled out gallons and gallons of oil. And they said they enhanced their compliance and their safety regulations and then were able to use that as a competitive advantage to get business they could not get before. Can you see a way that a college or a university could increase its employment law structure so that they could use that as a competitive advantage in recruiting?
Sure. Well, we always try to impress upon, whether it's a university or a business, that compliance is good business, and I think in the context of college sports, having a robust compliance program is good for recruiting, and in part, scandal allegations about abuse by coaches. Scandals like we've seen at Michigan State, for example, are obviously very negative things for recruiting. I think that colleges and universities, could do a better job of heading off those kind of situations and preventing kind of high publicity scandals and incidents that we've seen in college sports.
And the Michigan State University one was unique for several factors. I mean,
right.
Number one, they obviously didn't read their insurance policy. Did that surprise you?
No, it doesn't surprise me because I think it's not unusual that large institutions, corporations, universities, don't read all their documents, and you'd be surprised sometimes what people haven't read. But I do think in the Michigan State example, right, it's important when you're dealing with a crisis to be on top of those issues before you respond. And sometimes I think some schools have let the cart get a little bit ahead of the horse.
So if I was a responsible university president, I mean, the first thing I should do is call you and say, would you read over all our documents first and tell us what we're covered for and not what we're not covered for?
Sure, I think that would certainly be part of it, and I think part of it would be putting together an integrated crisis management strategy, which involves, as you know, not only lawyers but public relations.
And how would that
other
proceed for
aspects.
school? For Michigan State, was the doctor for the gymnastics team. He found out he'd been abusing the girls for a long time, and they found out they were not covered. The Michigan State legislature had to approve a $500 million bond issue to pay the bill, so good luck for getting insurance after that. I mean, what would an integrated strategy involve?
Well, I mean, certainly from an insurance point of view, you'd want to know, what your exposure is. You'd want to know how that exposure is going to be covered. But integrated strategy, I think, involves, both legal aspects, public relations aspects, insurance aspects. It's not surprising in the abstract that this conduct wasn't covered, because most policies don't cover intentional conduct. But there are ways when you're in this situation that you can put yourself in the best position to get coverage, and that would be part of it.
Well, when you look at the actions of doctors at Ohio State University, University of Southern California, and Michigan State University, which were obviously intentional actions, how would you cover that as a lawyer? What would you tell them to do to watch for that?
Well, I think that part of that comes from a culture that, from a compliance point of view and employment law point of view, is an undesirable culture. In other words, you have a culture of we're a family, we keep things in the family, we don't complain, we don't go to people outside the program. And the other problem with college sports, when you talk about athletes, is that retaliation is so easy. In other words, there's always more players on the team that are going to be able to play, and there's no real way to look at a coach or an athletic director and making those decisions about who plays, who doesn't play. So you have I think a cultural issue, and I can't speak to the specific situations, but you have a cultural issue that I think allows these things to snowball and go on for as long as they did. That has to be addressed first. In other words, you can manage the crisis, but when you get to the root causes of it, there's cultural issues that should be addressed.
And how do you address those cultural issues from an outside counsel point of view?
Right. I mean, I think you need to, create not only a culture of compliance, but you need to have your compliance structure integrated into the organization. In other words, going to somebody from HR, going to somebody from compliance is not, going quote unquote outside the organization or outside the program, but that those people are part of the program. And you look at, as an example, how both professional and college sports have integrated mental health professionals into their programs, where most professional football teams, for example, have mental health professionals that are part of the team, that sit at the team facilities, that travel with the team, and you've kind of erased or at least helped to erase the stigma of going to seek psychological treatment. Now that's an analogy, but that's the kind of process that you need in terms of integrating compliance functions, human resources functions into athletics.
So, having worked for some of the best law firms, I'm a big fan of law firms and what they do. And I was just stunned at the recent NCAA rules saying that agents only had to have a college degree.
Right.
And I would have certainly said they had to have a law degree, because I remember one time I was the only person there without a lawyer representing me, and it was not a pleasant experience, and I will never go through it again. Like
Sure.
I said,
Sure.
I'm a lawyer. How important do you feel it is for them to reach outside, their culture, as you call it, and go for outside legal advice?
Well, I think it's very important, and as we've been talking about, sports is becoming a business not only in what we call professional sports, but college sports and even younger, especially with the sponsorship rules that we expect to come into place. I mean, you could see 9 and 10-year-olds having sponsorship deals at this point. So athletes need to understand that they are, in a business, at least athletes at an elite level, and treat it like a business, which means getting good legal advice.
Now, is there a chain of custody for the sponsorships? Because I could imagine if I'm a school and I want to get serious about trying to help my student athletes make as much as they can from sponsorship dollars, I'm going to vet the sponsors. I'm going to make them come through the school for the deals and stuff. But suppose something goes wrong, say it's a bar or something like that, and the player has too much to drink and, has an accident on the way back.
Sure.
Will the school then be partly responsible for that since a sponsor came through the school?
Well, that's a possibility, sure. I mean, I think there's a lot of issues to be worked out with sponsorships, but one of which is what you mentioned is, how do you make sure that the sponsors are appropriate, right? How do you make sure that the sponsors are, that the sponsorship is consistent with the actions of the athlete, right? And how do you make sure there's not conflicts between the sponsorship deals of the athletes and the sponsorship deals that the schools themselves have? So I think you're right. I think the school is going to play a role in vetting, and I think you're right that the school is going to be, at least in the court of public opinion, held responsible for sponsorships, gone bad, as you might say. But you're right. I mean, and we see it, with charities, we see it with universities where they become connected with
Yes.
with donors or with sponsors, and then there's a scandal on the sponsor side, right? But it has an impact on the university.
So when you're talking about employment law in colleges, you're obviously talking about Title IX too. When you look at the marketing dollars that go out, most of it goes for college football. So how is
Sure.
that going to be if I'm the father or the lawyer, even worse, for a field hockey player, and I say, well, my daughter's not getting the opportunities for sponsorships that the football team is because, I look at this University of Wyoming study, and they said that each football player received the equivalent of $500,000 worth of branding. So how is that going to play out in the Title IX aspects of sponsorship dollars?
Right. I mean, I think that's one of the issues that needs to be worked out in terms of these sponsorship rules is, where is that money going to flow? Is it flowing just to the athletes who are doing the sponsorships, in which case it's going to be, most of the money is going to be going to the elite athletes in the revenue sports? Or is it going to be...
And is that legal?
And is that legal? Well, and it depends what the involvement is of the university, again. I think you're right. If you have universities that are actively arranging sponsorships for players, and they're arranging those sponsorships just for male athletes, that could be a Title IX problem. If you have, if the sponsorships are independent of the university, it's much less of a risk. So, again, I think it depends on how integrated, how involved the university is in arranging those sponsorships.
What three things would you tell college presidents and athletic directors to do to just protect themselves against, the myriad of issues we've talked here, whether it's, the doctors, the Title IX implications of the sponsors? I mean, would the first one be just basic review, have outside counsel review your documents?
Well, yeah, I think having outside counsel review your documents, having qualified in-house counsel is important. I think culture is important for the reasons that we've talked about. We need to combat cultures that are inconsistent with and don't facilitate compliance. And I think structure, which we've also touched on. But how is your compliance organization structured, not only from an NCAA rules compliance point of view, but from a point of view of compliance with employment law, with tort law, with all aspects of law? And how do you make sure that your athletic department doesn't sit outside that compliance structure, but that the compliance structure resides within the athletic department?
So let me ask you a question about compliance. I was reading a book about Bear Stearns when it collapsed during the Great Recession. And they would hold a compliance meeting every Monday morning at 8:30. And what they would do is talk about what they did that week and how their golf game went, how much money they spent. How would you say to the university, no, we've seen this with our other clients. You have to have real compliance, and that means you don't move the sports information director over to be chief compliance officer because they want that under their belt to be an athletic director someday.
Right.
How would you say to them, you have to have meaningful compliance that's going to protect you from outside lawsuits?
Right. I mean, I think meaningful compliance, number one, involves, as you point out, having qualified professionals who have experience in in compliance issues. And there fortunately is a wealth of people who've worked in governmental roles and in the private sector that have that experience. I think another part of compliance though is not making compliance incompatible with the other goals of the department, which are winning games, making donors happy, providing a good experience for student athletes, but making compliance into a partner with the athletic department and making it complementary to those other goals. And that's a lot easier said than done. But it can be done. It can be done in the corporate world, and it can be done in the academic world. But it takes a lot of work. So
certainly, when you look at the corporate world, I mean, it worked for ExxonMobil, and certainly the most the healthiest financial markets are the most transparent.
Sure.
Because they're the ones that. So, do you see in the future that more of the colleges will embrace that?
Yeah, I think that they will. I mean, I think that it's not a trend that's limited to colleges and universities. I think there is a general trend of understanding the importance of compliance and the importance of having qualified people doing compliance. But and I think that the more you see in terms of major scandals, Michigan State, Penn State, and other places, obviously.
Spending time in prison can wake up a college president's eyes to the potential.
Well, sure, and that was right. That was one of the outcomes of the Penn State scandal that I think surprised a lot of people, that there's not the consequences go beyond just the university, but into the criminal realm. So I think all of those things will sort of drive an increased culture of compliance, but it'll take time.
So, Mr. Phillips, as always, it's been a pleasure, sir. Thank you for taking the time to be with us.
Thank you for having me.
This is Jonathan Yates with HBCU Game Day Network. Thank you for joining us.